Attorney Ward, can you tell us about custody and visitation issues in a divorce case?
The main general point about custody and visitation in a divorce or family law case is the standard applied by the judge, which is, quote, the best interests of the child, quote. I always counsel my clients when dealing with anybody in the court system and dealing with the other spouse to try to state what they want for their children and their relationship with the children in terms of the child's interest. Judges are not necessarily eager by any means to tell people how often and in what relationship they will have with their own children. They'd much prefer that the parties work out that issue on their own. And it usually works best for everybody when the parties can do that. And indeed, there is a lot of pressure built into the processes of the legal system to get parties to do that. And I always counsel clients to be prepared for that pressure, to be willing to compromise as far as they can, but if they reach a point where they can't compromise and they're being pressured by family relations at a mediation session, not to give in. I always ask my clients not to reach any agreement in a family relations mediation without first talking to me. In a contested case involving children, as a matter of course, the court will appoint a guardian ad litem. In Connecticut, that's an attorney whose job it is to do an investigation, speak to the parties, speak to the child, and speak in court on behalf of the child's best interest. In a case that's contested, the court in most cases will refer the question of custody or visitation, if there are serious issues, to the Family Relations Division for an investigation and recommendation to the court. The Family Relations officers are trained to do that. They're officers of the judicial system, and they file a written report with their recommendations, and if there is a hearing, they are subpoenaed to testify at the hearing. It is a rare case where a judge would make a decision in a circumstance where both the guardian ad litem and the Family Relations Division were consistent in their recommendations. It would be a rare case that the judge would go against their recommendations. In conclusion, to get through a contested custody and visitation case takes a lot of effort on the part of both the attorney and the client. A lot of preparation is involved, preparing the client for dealing with the process and testifying at trial, doing investigation, and easing the client's concerns so that both the lawyer and client have confidence that a positive outcome for the client and the child can be achieved in the courtroom.